And my lords may adjourn for review.
So what is there in the matter?
I have been just instructed.
Interim order. Interim order.
May it please, Lordship. Lordship, may I have page 1 of my SLP. Here is a case where a challenge was put to an order and how the High Court dealt with it. Then I will come to the main controversy. Lordship, may I have page 1. The petition.
Who is for the respondent?
My lord, I am appearing for respondent.
There are quite a few, Lordship.
Huh?
I am appearing for respondent, my lord.
For what? Uttarakhand.
I am also.
I am for
also a
private
petitioner,
respondent.
Lordship. There is a second SLP which is filed by the state and the second.
But I am appearing for a few of the teachers who were to be appointed. We were also writ petitioners in the High Court. I moved an intervention here, which was allowed. We'll address your law.
Because we are in the same category of people who were party to proceedings there, but were not made parties here. The lordships have allowed us simply.
Yes. How many matters are there?
There are two matters.
Two.
Yes. Give us a brief fact.
Lordship, may I have? It so happened, Lordship, post the Right to Education Act of 2010, the Center in its wisdom decided that the recruitment of the teachers to the primary institutions is not in conformity with what is required otherwise to be imparted to the the young students or children. So the Right to Education Act, under that, the NCT was empowered to frame regulations governing the issue of rest of the issues apart from the recruitment.
Is there a rational council for teachers?
NCT, that National Council for Teachers Education, that's the council. So in its wisdom, it framed the regulations. Lordship may have the regulations first. That would be this. Now, Lordship may first have the page 1. The Lordship is asking me for brief facts. Let me explain to the Lordship before I take the Lordship to the SLP. So now the regulations were framed. In this cause, because this provided the teachers who are imparting the education in the existing teachers, since there were quite a few of roughly 70-80% of them who are not having the qualification which otherwise was required now as per the new act and the regulation framed thereunder by the NCT. So the NCT in its wisdom decided that these teachers already in service, otherwise the requirement was that of 2 years diploma in education or bachelor's in education with 6 months additional training, that is DLE and BL. So they would have become disqualified to hold on to the post. So NCT decided that those already in service, they shall be given a program. It was called a program of 18 months training through distance learning. They were not supposed to attend the classes. It was a distance learning so as to enable them to continue in service. It was one-time arrangement, just one-time arrangement, and a deadline was fixed. You have to seek this qualification by a particular deadline, that is sometime in 2019. Thereafter, you would be thrown out from the institution if you do not get this program done. 18 months. It was in any case distance learning and 6 months less than the requisite qualification otherwise prescribed for the teachers to be appointed in the primary institutions. Nothing wrong with that. Thereafter, the NCT made it clear in 2019 itself, look here, these teachers already in service would continue if they do it, this program, not a diploma or degree, program 18 months distance learning. Otherwise, for the fresh recruitment, the qualification would be as laid down in the notification issued in 2010 and 11 and 12. Thereafter, the state of Uttarakhand, like all other states, they put forth the advertisements in 2019. Recruitment started. 70% of the recruitment prior to coming up to the High Court and this court was already more than 70%. That's before the court, the secretary's affidavit. Against the advertisement which was put in 2019. So more than 70% have since been appointed. Now what happens? Somebody puts a challenge to the same in Patna High Court. asking him to be treated as being qualified on the basis of that 1-year program, which otherwise is available to the candidates who are having
Who are already only in service.
already in service. Now they want to be recruited through this channel as well. Patna High Court in this wisdom decided to say yes, treat them as qualified. Rather than putting a challenge to it against its own policy and everything, the NCT issued an order without there being a notification. In this wisdom, we are deciding to asking you adopted this order and they be treated to be qualified. So we put a challenge to the subsequent order, Law Lordship may have page 1 of my assent.
You are.
Page 1. And how the High Court dealt with it. Lordship having that page 1. Lordship may have, but the relief was short. Issue a writ or direction in the nature of the society calling for the records and posting the annexure 1 communication dated such and such, issued by the third respondent national council, the subsequent order issued by the Secretary Uttarakhand. This was put a challenge to the SEC's order whereby it decided to adopt the Patna High Court judgment. Now, what does the High Court say? Lordship may please to turn to page 2. Second last para. We have already rendered a judgment in the bunch of writ petition, including divisions dated such and such. Not dealing with this order, High Court is deciding another matter referred by my friend Mr. Hussein's lines. That petition came to be decided, and my case was relegated, decided in terms of the decision made in such and such. Now, Lordship may have. Now, Lordship may have. Page 168 first. 168.
So this is the only order that is under challenge.
No. High Court now. High Court. Based on
Whether this 354 is under challenge?
The state has challenged. It was a connected matter.
Next matter.
yes. It's my Lordship now. High Court has decided that holding them to be qualified. Holding it to be a qualification, not a program. Qualification.
In effect, the High Court has directed that 18 months program be
A qualification.
a qualification.
Qualification.
So the state is also agreed by that.
Yes.
Program is diploma.
Our service rules.
It is diploma.
But our service provide for 2 years.
2 years diploma. 2 years diploma.
Correct. Now, what the NCT by way of these letters is adopting Punjab, the Patna High Court judgment. By virtue of that letter, even override their own notification, our service rules, as well as the notification of the NCT. But by way of a simple letter saying that let us now start adopting these, can't substitute that with the notification.
Without amendment to the rules. Page 161. Their own stand.
Earlier, the state has accepted it, then they have proceeded to rescind it. That was the subject matter of challenge.
Lordship may 164.
If the state has committed
Annexure 14. Most important is dated as 6 September 2019. Of these teachers by 2007 communication to complete a program and to continue in service. Lordship is having that.
Initially, they were allowed to participate.
No. They have never been allowed. And they never put a challenge to the advertisement either. That's the best part of the whole controversy. No challenge whatsoever was put to the advertisement.
By 15/1/21 order, they were allowed to participate.
Yes.
Why do you say they were never allowed?
No, yeah, I'm sorry. Yes, now by the High Court, which is the challenge?
Not by the High Court, by the government.
No, that order was subsequently.
On, but initially, they were allowed to participate. And you said, no, they were never allowed to participate.
I thought.
Be careful in
I
making
stand
statement.
corrected. Lordship, I 164. This is communication by the NCT.
yes.
Those additional Chief Secretary, Education Department, Government of Bihar. It was probably during that period when the pending. Subject clarification regarding appointment of primary teachers possessing DLED qualification from NIOS directed report. Following points, Lordship may skip that. The following points NRC and city or dated such and such. DLED program is only, this is the one, those who have put the court, those petitions allowed. As per the NC such as the NIOS only for those untrained teachers in government aided private unaided schools appointed or before such. So it's a special class. Otherwise, yes. The duration of the program is 18 months. Now, Lordship, the second part is very important. Hence, for the press appointment of teachers for primary and upper primary level, the notification dated 2018-2010 and 29/7/2008 to be strictly adhered to TET is a mandatory requirement. Now, let's have those notifications. Lordship may have page 96-97. This is the first notification of 2010. The NCT. Lordship is having that. In exercise of the powers conferred by the subsection 1 of the section 23 of the right of children to free and compulsory education 2009, and in pursuance of the notification dated such and such issued by the Department of School Education and Literacy Ministry of Human Resource Development, Government of India, the National Council for the Teachers Education, NCT, hereby lays down the following minimum qualification for a person to be eligible for the appointment as a teacher in class 1 to 8 in school referred to in clause N of the section 2 of the Right to Children Free and Compulsory Education Act 2009, with effect from the date of this notification. Minimum qualification for class 1 to 5, senior secondary. This is the one which is the controversy for the court. Senior secondary or educated at least with 50% marks and 2-year diploma in elementary education, or senior secondary such and such, or senior secondary with at least such and such marks now, or senior secondary pass in the teacher's eligibility test to be conducted. Now thereafter class 6 to 8, let us skip it, Lordship. Now thereafter for 98, a training program, a person with a BA, BSc with 50% marks and B.Ed qualifications shall be eligible for the appointment from class 1 to 5th. January 20 provided undergoes appointment and NCT recognized 6 months. So for the B.Ed, they said you have to undergo a 6 months special program for the training. The 2 years diploma elementary education is a must. That's all the qualification is all about. Now Lordship may have page 133. 133, 134. And that High Court conveniently ignored this. Is a notification. Lordship having this lecture P6.
133.
133. This is to start as such. The exercise of the powers conferred under clause such and such, read with such and such, in suppression of the National Council for Teacher Education, Regulation 11, except as respect done or accurate. So this is a title. These are the regulations framed now. Now, Lordship may please to come to para 4. This is very important. That is important, but that is the High Court conveniently ignored this. This is the gist of the High Court's order. Power to relax. That is what the High Court holds, because the power to relax was there. Here's the relaxed. Power to relax. Where the council is satisfied, Lordship are having that para 4, on receipt of reference from the concerned state government that special circumstances exist, warranting relaxation of some of the provisions of the regulations, it may grant relaxation of that provision to such extent for such time, period, and subject to such conditions and limitations as it may consider necessary in a just and equitable manner. Now, Lordship may have the proviso. Provided no relaxation shall be with regard to the minimum qualifications for appointment of teachers for level 3, class 1 to 5, the subject matter of the controversy for the court. No relaxation is permissible for 1 to 5. Relaxation only permitted from 6 to 8. Now, Lordship may have this as specified in the first schedule. Lordship may please turn to next. 135. What is the first schedule? Lordship may come to para 3. Para 2 say. Senior secondary class such and such, mark teachers from the application and diploma in nursery teacher education, pre-education, early child program, duration not less than 2 years or B.Ed nursery from National Council of Teacher Education recognized institutions. Next para is very important. 2 years clear. Primary and upper primary for class 1 to 5, where the no relaxation permissible. What is the qualification? Minimum qualification as laid down by the National Council for Teacher Education. Why is notification dated?
Classes?
That's it.
You are right.
Para 3, class 3.
For classes 1 to 8.
1 to 5. 1 to 8.
1 to 8.
Yes. Minimum classes laid down by National Council for Teachers such and such, as amended from time to time, issued an exercise of powers conferred such and such, which are allowed to the court. So this is a 2 years program. Now, let Lordship may now come to the impugned judgment.
Where is the advertisement?
Advertisement, Lordship. I'm sorry. Yes, Lordship may have the advertisement. 174. This has never been put a challenge to. This still survives. The High Court did not say a word about the advertisement, which is that of 2019, 20.
29, 12.
Yes.
29?
29 December 2020.
For the districts, there are different dates. Okay. There are different dates for the different, because this recruitment to the class 1 to 5 is done by the district level, at district level. So different advertisements are different, could be different. Notification in compliance of the Lordships are having 20.
1
So they are having that access to the base in compliance. I believe Justice Gowai is the Lordship are having that. In compliance of the later number such and such, dated such and such of the Director Primary Education Uttarakhand, Dehradun, applications are invited.
Yes, read the 11, don't read.
Oh, Lordship, I'm sorry. Eligibility. Lordship may come to next paragraph. Graduation degree from university established by law for the purpose of filling up the advertised post of assistant primary teachers. 50% shall be from the science and 50% common science, from non-science. Now, Lordship may please to turn to
Clause C.
73 clause.
what C.
He should be holding bi-yearly diploma.
He should be holding bi-yearly diploma, DLED training, this BTC, or in fact being mandatory that the person appointed as a primary teacher for teaching class 1 to 5 should complete bridge course of 6 months in primary education from institution university within a period of 2 years while holding 2 years diploma, DLED, or graduate 50% math and B.Ed 2 years diploma in education science from institution recognized by NCT. It is mandatory that in accordance with the principles guidelines laid down by the National Council for Teacher Education, the teacher test should have been passed. It's mandatory. Then also may come to last paragraph. Aforesaid appointment shall be subject to the final order to be made by the Honorable High Court at petition such and such, filed in Honorable High Court such and such. Last date. Fully filled up application received through registered post such and such be accepted in the office undersigned by such and such date. No application shall be accepted after the date scheduled. Now, Lordship may have. Now, Lordship may have the affidavit of the secretary in page 284 to 291. This was before the High Court. Not a word on whisper on that.
Lordship completed. Persons who are holding 2 years diploma.
Yes, 2 years degree.
Or they are B.Ed holders.
B.Ed.
And they have been held to be ineligible
No,
for this.
that would
They
be
are
possible.
B.Ed holders.
Both prospective and 70%.
Petitioners were also B.Ed holders.
No. We are diploma holders.
They are, no,
Diploma
not
holders with that new
This scheme, under the scheme.
program, no diploma.
And as far as they are concerned, they are B.Ed.
Lordship, if they could show the diploma, I'm out of the court. It's a program. Distance learning, no 2 years, 18 months. Lordship, I have this.
Degree of education is B.Ed, na?
B.Ed.
Are you having diploma in education? Are you having diploma in education?
Yes.
B.Ed certificate.
Lordship, may record it.
We have diploma, but the issue is this is given in 18 months because of the notification, not in 2 years. That's the only difference. So 18 months have been treated on par with 2 years.
How can it be treated as 18 months?
For the reason.
Anyway, let them complete.
No, you see, High
Or there
High
is a
Court says
reason
in
for-
para 3, the petitioners possess degree of education, that is B.Ed.
Yeah, that's me.
That's
Your
they are-
petition has been,
No, I'm not. That's wrong.
your petition has been dismissed or allowed.
That petition is allowed, and that's why there's a challenge to it. I'm not.
Yes, therefore, these petitioners do not have B.Ed.
No, they're not.
High Court says the petitioners possess degree of education.
We are not B.Ed one. Or there is a restriction.
Is it right or wrong?
Wrong. Subject to lots, because they're petitions.
And they have cleared TET, teacher celebrity test. They have also obtained diploma as recognized by the NCT in elementary education in ODL mode.
Or they are in-house. They are in-house teacher.
18 months diploma. This 18 months includes 6 years training, which otherwise the 2-year diploma holders had to do.
That is
2 years plus 6 months training, vis-a-vis 18 months consolidated.
I'm only
NIOS.
and there is a reason
asking
because it's already
That's it.
whether the petitioners before the High Court,
They did not have the degree or diploma.
they did not have the degree or diploma, only 18 months ODL.
Program, it is especially called program. Now, Lordship map, page 287. This is the secretary's, the education secretary's affidavit before the High Court. At present, against the advertisement issued for the recruitment for the year 2018-19 and 2021, 70% selection process has been completed. However, the candidature of 21 candidates who are petitioner in the budget petition who are having 18 months DLED from NANES considered that situation, the regular DLED training candidates who have already been selected on the basis of which the merit is prepared would have to be amended by the department. In this case, several anomalies would occur. High Court, without there being a challenge to the advertisement first, without asking for any amendment to be carried out, without asking for a press report in the paper, so the date advertisement will not be qualified, would not have applied. High Court says, what does this? Now, Lordship may have impugned judgment. Makes very interesting debating laws. Let's have the program, one-time program, page 18. What is it all about?
Page
18 of the impugned judgment.
ऐसा है कि जो स्कीम आई होगी कि those who are already in service and they don't
Page 18. So this is referring to the program introduced. Now, Lordship may skip the part. Lordship may come to page 20, bottom paragraph. This is what the program which my friends, this just
Page
Mr.
20.
Kusin and Mr. Shukla before the court. These are the persons.
Yeah, because that specifically says that this program shall be only for those in service under teachers.
Yes, this is what they have.
Are they in service or?
They are in service. They are in service persons.
But if they are in service, they are entitled to be protected.
No, they have not been ousted. They are seeking now selection through the advertisement for which they are not qualified. They say treat us to be qualified for the press selection.
For the,
fresh selection.
but if they are already in service.
How could they? That is what I going to the court.
In fact, there are two categories of institutions: private management institutions and government institutions. So this
You are in service in.
we are in service in an institution in question already working.
No, in private.
Private or government?
Private institution.
Private,
Now
it
they
is,
are putting an employment in government also.
yes.
How can that be done?
Yes.
No.
Non-aided.
No,
They will be
it is a
not working.
it is non-aided institution. This will be aided.
Yes. So this is
Distinction.
only in order to protect wherever you are protected.
Yes.
Exactly.
That's
The
the
scheme is
idea.
that wherever you are there, you are protected.
Yes.
But then you can't compete with otherwise there will be a competition between non-equals.
Yes.
What? But the fact of the matter is,
We will hear yes.
Yes.
Yes, Mr. Uniyal, be complete quickly.
Lordship may turn to page 37, para 31 and 32. I'm taking Lordship to the findings of the High Court. That's it.
Page 37.
Page 37, para 31, 32. The High Court is interpreting it the way it wants it to be interpreted. On a plain reading, para 31 of the above provision, it is clear that the preference to notification by the central government is not to the minimum qualification, but to the academic authority authorized by central government, which is empowered to lay down the minimum qualification to be eligible for the appointment of teacher. This is a plain meaning of the section 23 of that. Lordship may read that. I will take Lordship to section 21. It is not even the responding case. The NCT is not authorized to academic authority under section 21 of the Act. The submission learned counsel for the petition, contrary to observation by the Supreme Court in Shiv Kumar Pathak's case. The minimum qualification has to be laid down by the academic authority authorized by the central government and not by the central government itself. It is the academic authority which has to be authorized by the notification. Here there is no notification, and the High Court, I will take the court to the finding. No notification required. While holding it, the quoting from the Lordship judgment in Shiv Kumar Pathak's case, it is required to be done by the notification. Lordship may note it. Now, in the next submission of the learned Deputy Advocate General that the recognition or such has not been published in the official gazette. This is very important. Notification. The relaxation such and such is not. He submits that the NCT has already issued notification section 23(1), which the High Court is running on in the earlier paragraph, laying down the minimum qualification and minimum concern have teachers eligible to such and such. His submission is that if the minimum concern have to be relaxed, the same can only be done through a notification published in Gazette. It is thus argued that the second is not obliged to take cognizance of order, declaration order such and such, which is binding and enforceable. The notification prescribes the minimum concern such and such. Learned 2 years. 2-year diploma in elementary education. Now, Lordship may please to turn to page 42. Page 42. Power to relax. This is most important. The one I read out to the court. This is a general power to relax, which is being taken note of in the notification which I read out to the court. It's a general power to relax on the recommendations of the central government or state government or union territory concerned or in cases for removal of any hardship caused in adhering to the provision of these regulations, keeping in view the circumstances peculiar to the said government territory, it shall be open to chairperson for regions to be recorded in writing to relax any of the provisional regulations in respect to any class category institution in the concerned category. Now, this is subject to that power tax which I read out to the court in page 132, which says it cannot be relaxed under any circumstances. Page 132.
No, but NCT regulation has been relaxed. In their own regulation, they have relaxed the requirement of eligibility.
There is a proviso. There is a proviso. Relaxation is there. There is a proviso. You can't relax for 1 to 5.
They are in service.
Of that communication, those persons who are in service,
In government service,
either
they get to continue.
if they were
If
in government service, they are completed 18 months, they would continue in the government.
Yeah, they'll continue.
1 minute, please. Sorry.
No, I'm sorry.
Yes.
I'm sorry. Also.
No need to.
Yeah, I'm so actually sorry. Also. I'm sorry.
If they are already in service in private institutions.
No.
1 minute. If they are already in service in private institutions, they will continue to be there
Yes.
after completion of 18 months. But now they can't compete for the open.
Exactly. Your Lordship is right.
No, but the notification says this program shall be only for those in service untrained teachers in government aided / private unaided.
That is for the purpose of those who are already continuing for their selection in case there is no fresh recruitment. This is fresh recruitment in terms of our service rules, where Lord, the relaxation does not apply. Our service rules continue to maintain 2 years plus 6 months training. Now, without amending either your own notification or the NCT, by virtue of a letter, they say you take that. Now that is not possible. Earlier, Lord, following that letter, we issued a notification.
I don't think, because the whole program is to train the untrained teachers under the RTE. The object is to train the untrained teachers.
So it's a
Therefore,
provision.
the sweep is to cover all those government aided, unaided, private
Yes.
aided, unaided.
Absolutely right.
Their qualification of 18 months program has been recognized by way of this regulation.
So that
Once
they
it is
could
a recognized
continue
qualification under the
Absolutely.
RTE,
Yes, so that they could continue in service and do not become ineligible because of the Right to Education Act.
They will continue.
Now they'll continue.
They will continue, but only in private.
No, whichever institution.
But,
Then private will continue.
May I just respond for
If we hear everybody at a time, will it be in a position to finish the matter?
Well, just respond for a moment, just then my learned friend will continue. Well, your lordships will have to decide. One thing is clear, that those who are in service, whether in government or private, will remain in service if they do the.
Wherever they are.
Yes,
They
yes.
will remain in service.
Right.
So the second question will arise, if they are in private institutions and they've got this qualification now, can they apply? That's the second issue, is whether they can apply. There's a distinction between fresh people applying and people in service somewhere applying. That lordship will have to consider that. So, my lords, the issue will be whether the rule that applies is for 2 years, or whether there has been a relaxation. Your lordship will have to consider that, whether there's been a relaxation, that's all. Now the other.
Whether that relaxation is by a notification.
Well, the relaxation is not by a
If
notification.
we hear everybody at a time, it will be difficult for us to
But
decide.
page 178 is the complete answer.
Lordship
Lordship will just keep this in mind, all this will be explained.
So Lordship, I read out to the court, this impugn order judgment itself says that in the Sipal Patak's case, it is required to be notified. Now, what does the High Court say itself in page 48? Put it contradicting itself. Page 48 on top.
Page
48 top. I mean, this either way, whichever the lordships go, but this judgment has to go. It's saying something which is contrary to what is earlier in paragraph. Now it says, merely because the recognition order may not have been notified, it does not do with force.
Page
48 top, para 44. How can you say that? When you are quoting from the Patak's case, it is required to be notified. You can't say that.
Yes, Mr. Sethi.
But I have formulated. What I have formulated, there are 6 propositions which I have formulated for your lordship.
Good.
In a sense, Lord, there are just 6 submissions which arise. The first one, Lord, page 1, your lordship has. NCT seeks to enforce its executive order of 6th of January, prescribing a qualification different from that as statutorily notified by it earlier on 23rd of August 2010. Now, both this 23rd August 2010 is a statutory notification under the
Issued under the provisions of the Act.
This Lord has amended on 27th of July 2011.
2010 as well as 2014, I think.
Correct. Again under section 23 and 2G of the RTA. Now the state government has framed and notified service regulations 2012 in conformity with these prescribed statutory qualification notified by the NCT. An unnotified executive instruction 6th of January 2021 cannot amend or override a statutory regulation notified under section 23. This is the first proposition. Second one is that has the advertisement of December 2020 and prescribed qualifications therein as eligibility for appointment, no service rules under which the advertisement was published. The petitioners have only sought a mandamus to permit them to be considered for appointment because these stipulations. Sought a mandamus to permit them to be considered for appointment because these stipulations in the advertisement. As long as the eligibility in the advertisement and the regulations stand, eligibility cannot be applied. And none of the returns. The third one, Lord, after the issue of the advertisement and once selection process to stipulations and rules governing the midway. State was drawing the GO on the basis of the letter. Because as according with the NCT regulations, section 20, no provision achieving the goal during the selection process would create and destroy the recruitment already made as existing and rules of as amended. The NCT prescribes 18 months diploma in elementary education by MIS. ODL mode as the minimum qualification by its executive order of 6th of January. It cannot prohibit 24 months diploma in elementary education plus 6 months by regular mode as in the opinion of the state. It is a better, more suitable qualification. If the state wants to hire better qualified teachers, it can always do so as part of state policy. The fifth Lord, I'm sorry. Judicial review can either extend prescribed qualification. This is your lordship's equal is the matter for this government.
The national prescribe only the minimum. You can't go below the minimum.
Correct.
But you are always entitled to prescribe something more than minimum.
Quite right. That's exactly what your lordship given in Satyapal Reddy also.
That is settled right from Adhyanam.
Lordship, please. I'm grateful, Lord. Your lordship also had recently, Lord, in Devendra Bhaskar 2021 SC 1116. And the last submission, Lord, the impugned judgment insofar as it relies on judgment of the single judge of the Patna High Court dated 21st of January 2020 is erroneous. The judgment relies upon a misinterpretation of the Bihar government to hold that the NCTE clarification does not mention that DLED program of NOS cannot be treated at par with the 2-year DLED course. As a corollary, the said clarification also does not say that both courses will be at par. The Patna High Court judgment is confined to the peculiar facts of that case and cannot be applied universally by NCTE to all states by a mere letter of 6th of January 21. Each of these are supported by the judgments, which I am not reading, but they are there for reference purposes. So, Lord, the sum and substance is that 75% of our recruitment is over. Today, Lord, the remaining, though there is no stay by this court, we have held our hand, Lord, because the recruitment process, we don't want to, in the teeth of the examining this, Lord, we don't want to go ahead. But nevertheless, Lord, the position today is there are total of 3099 vacancies, of which, Lord, 1849 we have already appointed. That means, Lord, there are about 235.
Oh, but that communication of NCT only makes it applicable to in-service.
Quite right, quite right.
Page 164.
Your lordship is right, Lord. Your lordship is right.
So wherever they are in service, they may be protected.
Exactly.
But how can they
If you are in unaided, you will continue in unaided.
And if you are in aided, you will continue in aided. If you are in government, you will continue in government. Yes, who wants to?
Just a position note regarding the vacancy position. It's important because today we are suffering a total deficit lot of 3.
We are going to decide the matter.
Lordship.
We are hearing it and.
Lordship. I am very grateful.
Yes, the question who is leading?
Very Lords, let me just put the proposition as we look at the matter. What was before challenge, before the High Court, was the order that was issued. The first order that was issued by the state was of 15 January 2021, by which the state had passed an order to include the candidates who possess the ELED diploma from NIOS. And subsequently, on 10th February 2021,
which is the first order?
Yes, my lords. My lords may turn to page 253 of the SLP, and then I will just come to the merits of the matter. That's it.
Page 353.
253, my lords. My lords, this is in the petition in state of Uttarakhand versus Nandan Singh Bohara. My lords have it.
Dusra petition.
And then I shall immediately come down to the main issue that arises in the matter. And in my respectful submission.
You are for the petitioner in this.
My lords, I was for the original writ petitioner in this. We succeeded before the High Court.
Original writ.
Yes, my lords.
You are the ones who are working in
Private unaided.
There is that I want to clarify that issue because I will take my lords through those various orders and the instructions of NCTE and the NIOS, including the state, that have been passed from time to time.
What is Lordship is asking is
Yes.
whether you are serving in private unaided.
Exactly, I'm answering just that part. We are different lots of people. We will be suffering. We will be serving in various things. But my lords, what I wish and what will be my submission for my lords' consideration is that every direction issued by NCTE as well as the state.
You are not answering.
My lords, we are working
Let
in
us
private, we are working
let us see to section
in
20.
aided, we are working in.
Let us see section 23.
Yes, section 23. My lords, can I, section 23 of the RTE, as well as my lords, we'll have to look at the NCTE Act, because NCTE Act, that's the authority which my lords have held, which will decide on that, at least that minimum qualification for the purpose of recruitment. Now, NCTE here has taken a view on what will be the qualification under this particular thing. There is also section 29 under the NCTE Act that gives it a power to relax if it's a policy of the government. In this particular case, because of the RTE Act having come into effect, NCTE took that policy decision to make it this 18 months as equivalent to a 2-year course. It's inclusive. So it's not something that it is not 2 years, but given that all these people had this huge experience and everything, and NIOS conducted the special exercise, they made it as an inclusive thing of that complete 18 months equivalent to the 2. But the question that I'm going to put before my lords, and I'm going to make the submission, is this. The issue of 18 years and 18 months and 2 years came up before Patna High Court and before the Tripura High Court. Both the High Court took a view that NCTE has passed explicit directions. The government has considered this, has made this module course to be able to meet with the RTE requirement of section 23. They upheld this particular qualification. NCTE accepted the order passed by the Patna High Court and the Tripura High Court, and so did the state of Uttarakhand when they passed the first order. Now, when they revoked this particular thing, they talk about a diploma given by NIOS. NIOS was an agency which carried on online diploma course. What they challenged at that time or they revoked was that online study. They were not on the period of 18 months or 2 years. That part had already attained a closure. And that is where I'm going to show that this entire argument number 1 is misleading, because that is why I wanted to start with page 253 and then show the order revoking it. May I show that first, my lords? And then I'll take my lords back to the the facts with couple of documents and the judgment.
Yes.
My lords, may please come to page 253 first. Yes. My lords, have state of Uttarakhand versus Nandan se, because that's the paper.
I think the document ought to have been referred from one.
My lords, I can take my lords, but it will make it easier for me to explain because this is the what is challenged before the High Court. That is why
Should have referred to the documents from one paper book only. It makes it difficult for us to jump from one paper book to another paper book.
My lords, I specifically asked yesterday which is the lead matter, and I was told this was the lead matter. That is why I marked this. I apologize then. I completely apologize, my lords. My lords, there is a very short. Do you have extra copies of this with reference to page 1?
Yes, we have come to that 250.
My lords, this is the first order which is passed, which is 15 January 2021. And my lords will look at the subject regarding serving DLED. My lords ask the question: training, untrained in-service teachers, degree obtained. Now, my lords may mark the word degree obtained from National Institute of Open Schooling for
This
appointment.
must be an English translation. This must not be an original.
My lords, this is original, I'm told. This was in
An original letter.
It is a translation.
It can't be
In
original.
our state, everything is in Hindi. Everything is in Hindi.
And that translation at times makes very difficult.
Very well. But my lords, I don't think anyone has really objected to
Okay, yes, please read it.
Yes. So, my lords, please let us see this. My lords, may come to third line. This is guidelines have been sought for inclusion of such applicants who have got.
Where are you reading?
My lords,
Read the entire paragraph. Please refer to.
I will read that. Please refer to your letter number so and so dated 11 January 2020. Now, this is written by the Secretary, Government of Uttarakhand, to the Director, Elementary Education. Please refer to your letter 11 January on the subject cited above, which guidelines have been sought for inclusion of such applicant who have 2-year DLED training, that is year 2017-18, within bracket 18 months duration. So it's a 2-year course, but completed in 18 months as per then direction of the NCTE and NIOS. Then through distance education ODL from National Institute of Open Schooling within the state to the advertisement published for filling up vacant posts of assistant teachers primary in government primary schools. Therefore, in pursuance of National Council of Teacher Education letter dated 6 January 2021, I am directed to state that such candidates who have 2 years DLED training, 18 months duration, and the year on which they qualify, 2017 to 18. So this is the only batch which was allowed by NCTE with a particular method of teaching through distance learning education from National Institute of Open.
To prescribe the education.
Yes. It's yes, my lords.
Therefore,
My lords, I'll take my lords.
section 23 and the section of the NCT Act.
My lords, it will be under the NCTE Act. And NCTE is one which prescribed this ODL, Open Distance Learning Program, for this particular 2017-18. It approved of NAOS.
Shows that notification.
Yes, my lords. My lords, can I show 255 for a minute, please?
Yes.
Because a lot turns on it, and I'll take my lords immediately to that document. 10 February 2021. So, my lords, this now says, and again it talks about National Institute of Open for appointment. By means of government letter of 15-1 on the subject cited, such candidates who have 2 years DLED, year so and so, 2017-18, 18 months duration, through distance ODL from NIOS within the state, and have as well as fulfill other prescribed criteria for post of assistant teacher have been permitted, allowed to be included in district-wise notification published for filling. In view of the fact that there is no clear provision in Uttarakhand, no clear provision. In Uttarakhand state...
It's again an incorrect translation.
My lords, may I try and read from Hindi? Somebody can read it for my lords. I may not be able to read it very well. I apologize. But they have a Hindi document. Maybe from there? Yeah. Can you read the Hindi document, please? My lords, can I read this? And they will read the Hindi also. They are pulling it out. Then, yes. Survey as amended for appointment of candidates who have 2 years DLED training through distance. So they don't talk about 18 months of this thing. They talk about 2 years everywhere because they have now understood that 18 months was an encapsulated course that was done under NCTE by NIOS. But the ground is different. That ODL we do not recognize. That is a they take who have 2 years DLED training through distance education ODL from National Institute of Open Schooling to the post of assistant primary. It has been decided by the state government not to include candidates trained from NIOS. So it's not a matter of 2 years or 18 months. That's an equivalent thing. But what they don't accept now is the NIOS, the candidates from NIOS to an open distance learning program in district-wise notification issued for filling up of vacant posts in government primary college. Therefore, in view of the above consideration, I am directed to say that government order regarding permission to include candidates who have got 2-year DLED training through distance open education from NIOS, notification for filling up vacant posts in the state is hereby cancelled. So, my lords, course treated as 2 years is cancelled is NIOS. Now, my lords asked me that question to take my lords that where NCTE approved of this NIOS, the government accepted it, and they said at that point in time, the RTE Act has come, the teachers had to be trained. Perfect.
Let us see the regulations also.
My lords, can I take my lords to the NCTE notification which allowed this NIOS?
No, Uttarakhand State Elementary Education Service Rules.
Yes. Can you give me?
The latest ones are at page 170 and actual P70.
170 in your petition.
Yes, ma'am. Page 170.
No, we are concerned about the ones which are in hope at the relevant time.
This one, 29th July 2019. Page 170 and actual P70. And the relevant portion, Lord, is on page, starts at page 171. Amendment of Rule 9. These are amended rules. Lordship has page 171.
That's Amendment to Rule 9.
Amendment to Rule 9. And please come down, Lord.
Because it is at page number 160 and 174. Yes.
174 is the.
And 160 also before that.
174, the second column, Lord, that is the one which is in force.
So can I first request my lords to take page 160? So my lords, at least now the letter by which it has been cancelled makes no distinction. It treats that 18 months as being the 2-year DLED course. I take that. It is, their letter does not say, and they say 2 years DLED course within bracket 18 months for the years 2017-2018. So clearly that is recognized. Because that's an NCTE qualification, my lords. The state cannot say that's the minimum qualification and that's the NCTE qualification. So there, it is not open to the state to deal with that. Would my
see what is the qualification prescribed under the regulation?
Yes, my lords, exactly. Please come to page 160.
2 years diploma in elementary education.
Education. That's it. And that is written to.
Read it, madam, further.
Yes.
Known as BTC in Uttarakhand from the concerned district Institute of Education.
Yes, ma'am.
And Training District Resource Center.
Yes.
So even the institute from which the diploma has to be has also been specified in the rule.
Can I answer that straight away, my lords? Can I answer that? It goes further. Yes.
Or Shikshan Mitra.
Or equivalent diploma in elementary education from any other institute recognized by National Council for Teacher Education.
Where are you reading that?
My lords, page 160.
60 which column?
My lords, the last column, 2 years diploma.
It's 2 years diploma in elementary education.
Yes.
So and so.
In BTC in Uttarakhand from any district institute of education and training, distinct resource center or equivalent to 2 years diploma in elementary education, DLED or 4-year BET from any other institute, page number 161, my lords, it carries on, recognized by NCTE. My lords have got that. Now, my lords, I must point out, and the High Court notices that previously, State of Uttarakhand had issued a notification where they said that we will recognize a DLED only which is taken from the state of Uttarakhand. That came to be challenged before the High Court and that was struck down. And the court said that whichever is the recognized institution by NCTE, that will be accepted. Now, that's not under challenge anymore. That is decided. That means anyone who studied from an NCTE recognized institution in Uttar Pradesh, Bihar.
Yes, you would be entitled to. The question is whether
now I'm satisfied that this is recognized. Now let me come to that part. First, let me take you straight away for the recognition by NCTE, page number 132, 133. I take it. Yes. Yeah. Yes, my lords. Page number 132. My lords, it starts at page 130, and this is issued by the NCTE.
Page
130, my lords. My lords, I will invite my lords' attention to that section 29 of the NCTE Act. It's important, but please read. Can I read it from 130? This is of some relevance. Whereas in the matter of recognition of project proposal of National Institute of Open Schooling, Noida, for DLED program through Swayam portal of MHRD, Ministry of Human Resource Development, for training of in-service untrained teachers was considered by NRC and NRC over as follows. Now, and whereas NCTE has received direction under section 29 of the NCTE Act from the Ministry of Human Resource Development, white letter so and so, so and so, the project proposal for recognition of diploma in elementary education program through ODL, my lord, it's not QDL, it should be ODL mode, has been submitted by National Institute of Open Schooling to NCTE headquarters. Proposal is for conducting online DLED program through Swayam portal of Ministry of HRD for
in-service untrained teachers.
I understand. My lords, I have to give that background. Actually, I started the reverse way. I should have probably started the other way. My lords, what happened is that once the RTE Act came in, it was necessary that the teachers must be trained. They could not be, but we had a lot of teachers across the country, and my lords will find in here was the DLED. Now, NCTE, through this particular method, carried out these teachers to be obtaining their DLED qualification. Once they get this qualification, they are comparable, equivalent to any other teacher for primary education, provided they have the other qualifications, namely they have passed the TET exam, namely that they have the basic qualification, whether it's graduation or 12th standard, with 55% marks, etc. Well, this was only to bridge that gap.
Therefore, what will be relevant is the directions issued by the Union of India dated 21st of August 2017 and 4th of September 2017.
I am grateful.
What do they provide for?
Now, my lords, can I first show this and come back to that, please, if you'll just give me a minute? Now, that is mentioned here, just the next page. I just wanted to show that the government approved, the NCTE approved under the direction of the government. And section 29 under the NCTE Act is a policy relaxation principle where NCT will act in directions of the government. I'll just come to that. Just give me half a minute, please. Now, if my lords may turn to page 131. This is what then the NCTE directed. My lords, at 1, 2, 3, 4 in I would have liked to read a little bit more if you would just allow me that.
Yes, yes.
Yes, I'm so grateful. So, my lords, this is, and then, my lords, please come to page number 131. And whereas from top of it,
whether by any valid lawful amendment to the regulation, these two qualifications have been made equal. You see, equivalence has to be by the same government or same agency which is recruiting. The recruiting agency has not advertised either by way of a notification or by corrigendum that we treat these two qualifications as equivalent. Where is that equivalence notification? By the recruiting agency. By process of reasoning, we cannot equate.
my lords, I'll have two submissions into my lord's
There are-
query.
Yes.
One, I will go to the advertisement. And
This is a relaxation.
My lords,
This is a relaxation, not a
respect-
substitution of the
no,
rule.
my lords, with respect, I beg to state that by this particular 18 months course, we had the DLED degree. We had.
Read the word.
So that is,
Mandate relaxation.
no, my lords, please, with respect, no, it was a DLED degree. It,
Please
can
read-
I please read it a little?
Please
further?
read it, yes.
Yes, please allow me to read that. Please allow me. And whereas, my lords, page 131, would my lords read that paragraph? And whereas, in view of the above directions of Ministry of Human Resource, under section 29 of NCTE, and after considering recommendations of expert committee, my lords are aware under section 12 of the NCTE Act, it is the expert committee that formulates the entire syllabus or the method or what is the qualification of.
Read it further. Please read it further.
Yes. The chairperson NCTE in exercise of his powers under clause 12 of NCTE, a norm so and so granted relaxation by
And
letter.
mandate relaxation.
Yes, my lords, can I read further,
Yes.
please? Let us go further to following provisions in the NCTE regulation 2014 for ensuring that the directive of MHRD for implementing the amendment to the RTE Acts are duly fulfilled. Then what are those relaxations, as my lords put to me? Any provision relating to online submission of application in the note application portal. Number 2 is important. Any provision relating to the duration of program so as to reduce it to 18 months instead of 2 years, and the requirement of 6 months internship to be subsumed in the duration of 18 months. Why? Because we were teaching. We were already working. That is why. Now, then, my lords,
NCT regulation 2014.
and they rightly pointed out to me.
NCT regulation जो है 2014 में that is 3134. The other day. इसके वाले में.
My lords, I missed out 2 lines.
Yes, yes, please read.
My lords, the top of the page. I have missed out. My learned colleague pointed out, my lords, and I think he's absolutely right. Please see the top of that page 131. Oh, I see my lords haven't got that page. I'm sorry.
No, we don't have any problem.
Okay. My lords, top.
You have some problem.
I am quite sure, my lord. My lords, I hope I'll be able to read that.
They are only prima facie saying.
Yes, and my lords, absolutely. And my lords have a right to put those questions to me. Absolutely. I am bound to answer. If I fail to answer, my lords will take a view one way or the other. That's
Therefore, what would be relevant is what are the directions issued by the Ministry of Human Resources and Development.
absolutely. Yes.
I'm sure that those directions would be only in order to provide qualification to persons who are already in service so that the provisions are brought under the RTE Act is fulfilled. And if that is so,
Yes.
this notification will have to be read in that limited restriction.
My lords, my lords may perhaps be correct on that particular aspect, but I will just add one submission once I've finished. And I'll just tell my lords where I would be coming from. My lords, it is an admitted position, and there is a letter that about 13 lakh teachers across the country did not have the DLED qualification at that point in time in India, which I will be able to show to my lords in a moment.
2009
मैंने बोल दिया
बोला है
वो डिफरेंट है
डायरेक्ट
Yes.
My lords, it's also a position that those people had to be, it was a directive of the government, Ministry of Human Resource, that either they get the qualification or they will be out of service. That is what the letter was of the MHRD.
So
Now, I
therefore,
will
in
show
order
that.
to save you from going out of service,
My lords, I will not say it's going out of service. No, it brought us into a qualification. We attained the qualification that was required. Once we have attained the qualification, we are at par with everyone.
okay.
That's going to be the submission. Just give me a few minutes, my lords, to put that through. My lords, may see page 131 on the top. The committee considered the project and found that NIOS is adequately prepared to conduct a program and curriculum proposed therein meets the requirement of DLED ODL. My lord, this is what NCTE expert body says, that if you do this particular course through NIOS, NIOS is prepared and its curriculum meets the requirement of DLED. Once I finish that course of 18 months,
You're on par with them.
I am at par with them, is what I am saying. And that is what my submission is, my lord. So, my lord, let's now go a little bit further. I had missed this out. And now, my lords, please see now what is the rest of the eligibility that I have to meet immediately thereafter. Any requirement of minimum eligibility for admission to DLED program, that is 50% marks in the 12th, to the extent that those who do not fulfill this requirement shall be allowed to take a provisional admission to the program, subject to acquiring 50% marks before completion of DLED. So if you don't get that 50% marks, you will be out. But you have to get it. We are giving it to you provisionally, but you have to meet it. Then, my lords, any provision in the regulation to enable NIOS to administer the program through Swayam portal of MHRD.
All relaxation is granted to you. Even if you don't possess 50% of marks in 12, you are entitled to take provisional, provided you again appear for 12th and clear that.
I clear that.
So again clear that it is only to meet the special circumstances.
So, my lords, please see now a little bit further. Give me a moment. I know that there are a few other paragraphs. My lords, just please come to page 132. And these first three ones is what that I wanted to read. Any provision prescribing the number and nature to study centers to enable NIOS to cater to 11 lakh untrained teachers. So this is what they recognized at that time across the country. So, my lords, the idea was not one Uttarakhand. It was across the country that you have these untrained.
Because you had all the untrained teachers throughout the country, and either they had to be regular, they had to be trained.
They had to be trained.
Either they had to be trained or thrown out.
Absolutely, my lords are right. So we are the people who went through with this training, qualified this training, and got our DLED.
And saved yourself from throwing out.
My lords, perhaps yes, but my lords, we did go through with the training and we did qualify it. Yes. And we did qualify through something which was set up by MHRD. It was not something like an, my lords, we could have done.
Yes, please proceed, madam.
My lords, it could be from one of the colleges which is not so good. This is something that was set up by the government. It had certain standards. Next, allow NIOS to operate study centers manned by staff, academic and others, as per instruction of MHRD, to enable NIOS to complete training of in-service teachers numbering around 11 lakhs by 31st March 2019. Any provision in regulation restricting the intake capacity program to enable NIOS to train the required numbers of untrained teachers. Would my lords now turn to page 133 at serial number 8 therein, Roman 8 down.
Read para 9 also.
I will read that.
Besides the above relaxation. So it's all relaxation.
My lords, I just was this. My lords, relaxation, yes, at that time, only to avoid throwing them out. But it said that if you do not get this degree by 31st March 2019, we will not keep. And we got it, and they recognize in their own letter.
Unless you got it by that day.
We got it by that
Yes.
day. We got it.
The thing was that you get that degree by that day and be inside.
Or
And if
outside.
you don't get, go outside.
Go out. Absolutely, my lords are correct. And we would have all gone out. My lords, private, government, or aided, anything, we would have gone out of all jobs.
Yes.
That is. Now, therefore, I wanted to read serial number Roman 8 on the next page at 133. This program shall be only for those in service untrained teachers.
Clause.
My lords, at page 133, there's a Roman 8 at.
And that's what my learned brother also read.
Yes.
It's only for
Yes.
those in service untrained teachers in government, government-aided, private and schools appointed on or before and so.
Yes.
Again, an indication that it is only to protect your services if you are already there and not possessing your qualification.
My lords, that may be so at that given point in time. My
Yes.
lords are absolutely right. I cannot.
Please point out that MHRD regulation.
Yes. Just the last bit also. My learned colleagues all asked me to read that. All provisions in the NCTE Act and regulation, other than those relaxed under clause 12 of NCTE, will be applicable. So everything else will apply. Now, my lords, in exercise of powers vested under section 14(3)(a) and 15(3)(a) of the NCTE Act, the Northern Regional Committee hereby grants recognition. So, my lords, I have been thrown out because I have got an ODL degree from NIOS. This is NCTE granting recognition to NIOS. That was the basis to throw me out, that I am from an institute, NIOS, we don't recognize it. But it has to be recognized by NCTE, NCTE recognizes it. Hereby grants recognition
Yes, please.
to National Institute of Open Schooling under clause 716 of the note that recognition norm so and so for DED ODL program through Swayam portal of MHRD for training of in-service untrained teachers subject to fulfillment of conditions above. Now, my lords, ask me that part of the MHRD document.
Before that, you please just answer.
Yes.
There are two different regulations. This regulation, first regulation is determination of minimum standards for recruitment of teacher in school, regulation 2001, amended in 2014. That provides for the minimum qualification for recruitment. That has not been amended. Neither this notification
Yes.
has been issued in exercise of powers under that regulation. This page,
That section.
yes, page 130, and if you see, this minimum qualification regulation was issued in exercise of powers under section 12A of the Act. 12A says specifically about the qualification, about the minimum standard.
1 minute, my lords, just can I?
The source of power, let us see.
You-
Section 12 says power of council to determine minimum standard of education of school teachers.
Yes, my
In
lord.
exercise of this power,
Yes.
this minimum determination of minimum qualification for recruitment has been made,
Yes, my lord.
and this has not been amended. Now come to your notification, which you are relying just now. You were reading page 130.
Yes, my lords.
This has been issued in exercise of powers under section 12 of NCTE
Yes.
recognition norms and procedure regulation 2014.
Yes, my lord.
That is a different regulation. And that itself is by way of exercise of powers under section 29.
Yes, my lords.
Section 29 says directions by the central government.
Yes, my lords.
So
Yes.
this notification is in form of a direction issued in exercise of powers under section 29 without amending or touching upon this 2014 regulation, whereby the determination of minimum qualification for recruitment of teacher has been promulgated.
Yes.
Now this regulation has not been amended. Neither section 12A power has been exercised to issue this notification which you are relying.
So, my lords.
Even if it is taken in your favor,
Yes.
that this notification also covers you.
My lords, can I?
This is apart from our objection to the equivalence part.
Hmm.
Because equivalence can only be by amending this regulation of 2014 for prescribing the minimum qualification.
Yes.
And that HRD communication will further make it clear. Because these notifications describing the qualification are provided for under clause 12A.
Yes.
Sorry, section 12A.
The NCT.
Read with 32(1)(dd).
Yes, my lord.
Yes, 32.
32(2)(dd). 2DD.
This regulation of 2014.
What has been done, therefore, is relaxation in terms of the powers under section 29.
Yes, my lords, can we have 29?
29 and 32(2)(dd).
Yes. So 29 is the power, and that is why I have to show it to my lords, the MHRD directive.
MHRD directive would be very relevant.
I will come to that immediately. That is that the Anita Karwal's.
Lordship, may I also
I
ask
just showed that.
23(1), which the Lord Chief Justice Gawai asked at the very outset.
RT